Nakwi, and a crucial update for all our viewers out there, because the Supreme Court is currently reading its judgment on a plea challenging the remission granted to the 11 convicts in the Bilkis Bano rape case of 2002. Now, some important points that have come out of the hearing, and they are that the Supreme Court has said that the petition of Bilkis Bano challenging remission of sentence to the 11 convicts, it was maintainable. The Gujarat government was not competent to pass the order, is another major verdict, part of the judgment by the Supreme Court. And the Supreme Court says that the government within whose jurisdiction an offender is tried and sentenced is allowed to decide remission of the sentence of the convict. The Supreme Court also went on to say that one of the convicts had suppressed facts and misled the apex court, which had asked Gujarat government to decide the remission plea in 2022. A bench of Justices B.V. Nagarathna and Ujjal Bhuyan had reserved its judgment on the 12th of October in 2023. Now, some important points that have been made or said inside the Supreme Court. They say that Justice Nagarathna, also citing Plato, of course, stated that punishment is not for vengeance but for reformation. She also went on to say that curative theory likens punishment to medicine. If a criminal is curable, he should be set free, and this is what forms the heart of the reformative theory. Nagarathna, Mrs. Justice Nagarathna also went on to say that the victim's rights, Bilkis Bano in this case, is also important. A woman deserves respect. Can heinous crimes against women permit remission? These are the issues which certainly arise from this. The Bilkis Bano trial case was transferred from Gujarat to the Mumbai, and the Central Bureau of Investigation investigated the case. Supreme Court holds that the state of Gujarat was not competent to pass the remission orders. And on this ground alone, the writ petitions are liable to be allowed and the orders are liable to be declared as a nullity. But the matter does not end there. Reliance was placed on earlier judgment which directed Gujarat government to consider. By suppressing material facts and making misleading facts, a direction was sought by the convict to the state of Gujarat to consider this particular remission. Now, meanwhile, to make the viewers understand in layman terms, in easy language, joining us here in the studio is my colleague Ashok Bagria, legal editor for News9. Ashok, first and foremost, the most important points that have come out of this hearing, and I mean, why should it be as a, act as a precedent for all the other cases in the Supreme Court and various courts?
Well, in a way, what's really transpired in the Supreme Court is really path-breaking. Path-breaking in the sense that the government has cleared the air around which is the appropriate government with regarding to giving remission orders or making orders for premature release of convicts. Now, this is a very controversial case because it happened during the 2002 riots, where Bilkis Bano and Bilkis Bano, the victim, was raped and her family members murdered by a righteous mob in March 2022. Subsequently, she approached the Supreme Court through the NHRC seeking the transfer of the case from Gujarat to any other state. The Supreme Court intervenes, passes an order, transfers the case out of Gujarat to Mumbai, where the trial takes place. The trial court acquits all of them, but interestingly, the Mumbai High Court reverses it and convicts all the people in the case. Subsequently, matter comes to the Supreme Court, also Supreme Court upholds conviction. But 11 years later, what really happens is that one of the convicts approaches the Supreme Court saying that, look, they have done requisite amount of years in the jail because they were sentenced to life imprisonment and they are entitled to premature release under the policy of the Gujarat government as it existed. And the policy was a 1992 remission policy. The Supreme Court passes an order asking the Gujarat government to consider their remission application, and subsequently Gujarat government considers the orders and orders them to be released. And on 15th August 2023, these 11 convicts were released. However, after this remission order, all hell breaks loose. There are a clutch of petitions which are filed in the Supreme Court, which includes also Bilkis Bano. Bilkis Bano comes to the court saying that this remission order is illegal. Various arguments were made in the Supreme Court during the hearings. And today, the most interesting thing that the Supreme Court says is that the Gujarat government was not the competent government to pass a remission order directing premature release of these 11 convicts. This is number one. Number two, it clears the air around the law. It interprets the law and says that in cases where the trial of a case is transferred from one state to another state, the state in which the trial takes place is the relevant state, and that the government of that particular state is the relevant government to consider the remission or to pass remission orders. So to put it simply, here the Bilkis Bano case was transferred to Mumbai, that is Maharashtra. The Maharashtra government is the appropriate government to pass remission orders and not the Gujarat government. The court clarifies that the place of occurrence of crime and the place where the convicts are jailed are not relevant when passing remission orders. So remission orders must come from the place where the trial took place, the state where the trial took place. And in this particular case, the trial took place in Mumbai, and the Maharashtra government is the appropriate government. Kabir, at the moment, Justice Nagarathna is still reading out the verdict. But the crux of the judgment is that the Gujarat government's order releasing 11 convicts prematurely has been set aside.
Well, so what happens to the convicts now, Ashok, essentially?
Well, as far as the convicts are concerned, they'll be taken back into custody. They will be sent again to the jail. And if they want that a remission should be granted to them, they should file an application before the Maharashtra government, or they should file an application in the Mumbai High Court saying that they have filed for a remission, and the remission guidelines or the remission policy must apply into their case. But that's still going to be a little time away before the Maharashtra government considers it. But at the moment, what will happen is that once these orders of the Gujarat government releasing these 11 convicts is set aside, they will be immediately taken into custody, sent back to the Godhra jail. And now if they want a remission or premature release, they will have to approach the Maharashtra government.
Competent authority or not, like you mentioned, in this case, it is the Maharashtra government. The arguments of the convicts, you know, how they've been pleading, for compassion and their freedom, citing Article 32 of the Constitution, we have our own liberty. How strong are those arguments?
Well, interestingly, Kabir, what has really happened is that the Supreme Court has come down very, very heavily on the respondents, that is the convicts. The convicts had in 2022 approached the Supreme Court and said that, look, we are entitled to be prematurely released as per the Gujarat government's 1992 policy, and please direct the Gujarat government to consider our remission application. And at that particular point in time, the Supreme Court, a division bench, a two-judge bench of the Supreme Court had passed an order directing Gujarat government to consider their applications for remission, and it was only after that that the series of steps were taken. But here today, what the court has held, the Supreme Court has held, that now not only have they set aside the 22 judgment of the Supreme Court, but have also come down very heavily on the respondents, that is the convicts, for misleading the court. The court has noted today that a fraud was played on the Supreme Court of India, whereby the respondents, when they approached the Supreme Court in 2022, did not disclose to the court that they had filed an application seeking remission before the Maharashtra government. And at that point in time, an opinion of the District Judge Mumbai, the CBI and other authorities was sought, and they had given a negative opinion. They had said that these convicts should not be released. That was suppressed from the Supreme Court of India. And suppressing these facts, the 2022 judgment of the Supreme Court was taken. But today the court is saying that, considering that everything, material facts were suppressed, everything was based on fraud, we are going to wipe the slate clean, and everything should begin from the beginning, in the sense that these remission order is set aside. These people have to be taken back into custody. If they want to file for remission, or if they believe they are entitled to a premature release, they should file such an application before the Maharashtra government. The Maharashtra government will then seek the opinion of the district judge of the trial court, which convicted these people, whether a remission should be granted or not. Opinion of the CBI should also be sought, because CBI was the prosecuting authority in this case. Earlier, this matter was investigated by the Gujarat police, but Bilkis Bano had approached the Supreme Court expressing her desire that this matter should be investigated by the CBI. The investigation was subsequently transferred to the CBI. And this is where we are today. It's been almost 2 decades since this incident took place. And Bilkis Bano has spoken in the media saying that she felt very, very offended, and a sense of justice not being delivered to her occurred when these 11 convicts were released on 15th August 2023.
Right, and I mean, with the garlands and all the sweet distribution that also happened right then after was also something that did not go did not go nicely with the community, with the nation at large. The community certainly divided on that front. Talking about the 1992, the policy, the act that you're talking about, this is specific to the Gujarat government. And if so, does the Maharashtra government have something like that the respondents, the convicts in this case, can now, approach or use?
Well, every government, every state government has a different remission policy. In fact, Gujarat government had a separate remission policy under the 1992 remission policy. There was no difference made between ordinary offences and grievous offences, and people, those who were convicted for life sentence, were entitled to remission after serving 11 years in jail. However, of late, recently, most of the state governments have made changes in the remission policy. They have made a distinction between offences, and state governments believe that people who have been convicted for grievous offences like rape, cum murder, destruction of evidence should not be prematurely released, because they will continue to be a menace to the society. So on these grounds, a lot of things have changed after the 2002 incident. But here again, what will have to be seen is that what is the relevant remission policy which will apply to these set of convicts, because the remission policy that existed in 2004 or prior to 2004 will be the remission policy even of the Maharashtra government, which will apply to them. So we'll have to see and wait and read the fine print as to what is or what was the Maharashtra government's remission policy in 2004, which will be now applied to these convicts if they apply for remission.
But until then, custody of these respondents back with the local authorities, the relevant authorities. They are going to be, the process must have, at least begun. I'm sure the doorbells are ringing in various local authorities about how to wind these respondents up and probably take them back. We also have with us Anuja Pethia, advocate for the Supreme Court, with us on the broadcast. Anuja ji, take a look at this. Justice Nagarathna goes on to say that usurpation of power arises when power vested in one authority is exercised by another. Applying the principle in this case, having regard to our answer of quote-unquote appropriate power, Gujarat government exercising the power was an instance of usurpation of power. Your opening comments as we're learning that the Supreme Court has quashed the remission of all the 11 convicts.
Yes, so Supreme Court, Justice Nagarathna rightly framed 4 issues, and the last issue she framed was whether remission orders were in accordance with law. So over here is where this comment was made with her, where this was held that exercise of any power. So this power which is vested under 432(7) of the CRPC, assuming that even that the state of Gujarat was the rightful or the appropriate authority to exercise this power, it had to be done through a speaking order. Justice Nagarathna specifically held that the order was not a speaking order. There was no application of mind. All the 11 applications for remission were passed very mechanically. So she is held that wherever any discretion has to be used by a government, it has to be via a speaking order. There has to be reasons which have to be given, and the reasoning is something which is something which can be read by all and can be connected to what is the result. So she also upheld that there are various factors that have to be considered while passing such orders. One of them is proportionality, which was the main issue, one of the main issues that the public had raised in this particular case, that whether remission of convicts in such a case, and even when they were in parole, their conduct was not the best conduct reportedly, whether remission could have been granted. So one was proportionality. The order passed by the Gujarat government said nothing on proportionality. It did not say anything at all as to why remission was granted. So she indicated that it may have been a colorable exercise of power and it may reek of malefice. She did not say anything specific, but she held that wherever orders are of this nature, they have to be tested on the peril of this court.
Interesting points. Ashok, Justice Nagarathna over here as well, saying that we hold, number one, Government of State of Gujarat had no competence to entertain the applications for remission or pass orders thereon. And number two, this court's order dated 13/05/2022 obtained by fraud a nullity. All proceedings taken in furtherance of the judgment are also vitiated and a nullity in law. So essentially nullified, right? All those orders, the remission order, that has been nullified.
Well, Kabir, here, what is interesting to note is that a lot of facts, material facts, was suppressed by these convicts when they came to the Supreme Court in 2022, saying that we want the Supreme Court to give a direction to the Gujarat government to consider our remission application. Now, it is in this context that Justice Nagarathna and Justice Bhuyan are saying that this 2022 orders of the Supreme Court were obtained by fraud. Fraud in the sense that these convicts, number one convict, that is Ramesh Bhai Shah, who had approached the Supreme Court, had suppressed facts. They had suppressed the fact that they had also filed an application with the Maharashtra government seeking remission, and the same was rejected. Had that been told to the Supreme Court, things would have gone in another direction. But that was suppressed by these people who had approached the Supreme Court. Hence, now what the Supreme Court is doing is saying that the 2022 judgment or the order of the Supreme Court was something which kick-started this process of remission for these convicts. Now what we are doing is that we are setting aside this 2022 judgments on two counts. Number one, that the 2022 judgment is bad in law because there is a 9-judge constitution bench judgment on remission, which is and this 2-judge judgment is against that. Number two, that there was a fraud which was committed by the convicts when they approached the court. They suppressed facts, and hence anything that has happened subsequent to 2022 order of the Supreme Court goes away. Secondly, when the Gujarat government considered the remission application of these 11 convicts, it was usurpation of powers by the Gujarat government, which is not permissible in the law. And they've said that the reason why we are striking down this remission order of the Gujarat government is that it is illegal. They were not competent to pass this remission orders, and also that there was a fraud which was played on the Supreme Court by these convicts who sought premature release.
Well, so essentially three things that have happened. Number one, the Gujarat government not competent enough. Then you have the order that is bad in law in the first place. And of course, the usurpation of power. These are the three things. And of course, the fact that the respondents, when they moved the Supreme Court, they had suppressed facts, which is why on the grounds of fraud, there is nullity when it comes to this particular order. Now, the Supreme Court recently, I mean, I'm on, since the reading is still on and I'm having to go through, X on various, social media websites, what exactly the Supreme Court is, hearing at the moment. Justice Nagarathna says, since we have squashed the remission orders, what follows is what the Supreme Court is now asking. In our view, personal liberty is important, but this is a case where 11 convicts are granted liberty on a remission order which has been quashed. So should they be sent back to prison? With a big question mark. This is the Supreme Court. How about I let Anuja Pethia come in here on this delicate question. What now, Anuja ji? Should they be sent back to prison? I mean, this is something that the bench is asking themselves.
Yes, so the answer should commonsensically be yes, because the remission order by which they were outside the prison has now been quashed. So there is no order on the basis of which they can be outside the prison now. And then there is a second question that the authority, appropriate government, which is now Maharashtra, will eventually have to consider, which is that we are looking at convicts who have committed a heinous crime. Like gang rape, and apart from that, they have come to the Supreme Court and lied on affidavit to the court. So this again, are these the sort of people who can be let out on remission? This is a question that the appropriate government will have to consider, apart from the other legalities under 432(7). So as of date, there is no legal basis for them to be outside prison. So that should be the commonsensically that should be the answer to this question. But let's see what the court holds.
Well, absolutely. Like Ashok also pointed out, we'll have to wait for the final print. The Supreme Court also goes on to say, Ashok, and I mean, I'd really love your input on this. It was also contended that since rule of law was violated, justice can be done only by sending them back to prison.
Yeah, this is one of the arguments which was made by Bilkis Bano and other petitioners in the case, that look, in case the Supreme Court decides that this particular order of the Gujarat government ordering their premature release is bad in law, then they should be sent back to prison, because that's the most logical thing to do. But here the Supreme Court is trying to deal with even more delicate question. Now they are saying that here, on one hand, we have the personal liberty of the convicts who have served their sentence, not the complete sentence, but the sentence, and they were given remission. And on the other hand is the right of the victim to seek them to send back to the jail. Now they, at the moment as we are speaking, this is something which the Supreme Court is going to answer in the next few minutes, but this is a question which has been raised, with which the Supreme Court said that it struggled. We are still waiting as to what the answer is going to be, but the logical conclusion here is that once the remission order is bad in law, the status quo ante comes into effect. That is, the convicts which were released, that order is set aside, they have to go back to the prison. But here, what has happened is that for more than 6 months, these convicts have been out.
Right.
Okay, so here there is a problem of their personal liberty and the rights of the victim, which wants that these people should be sent back to the prison. So I don't know what kind of an arrangement the Supreme Court is going to carve out from here on, but we'll have to just wait and see, as we are telling our viewers that the judgment is still being read out by Justice Nagarathna.
Right, and you know, it always gets interesting when the Supreme Court starts questioning the Constitution. The Supreme Court starts, shooting, in the dark. Now here saying, should rule of law prevail over personal liberty? I mean, these are questions that would probably open up a discourse at home as well, Ashok.
Yeah.
Only when rule of law prevails with liberty, including the right to equality, whether liberty has any meaning in the absence of rule of law. In our view, the Supreme Court bench says, as per Article 21, person is entitled to liberty only in accordance with the law. Anuja Petia, your opinion on this one?
Yes, so absolutely. A person is entitled to liberty only in accordance with law. That is the whole concept of rights in our country or anywhere else, that every right comes with its set of limitations and duties. So there's a very important judgment, Lakshman Naskar, which was given by Justice Lokur, where he had said that whenever the question of remission comes, you have to consider various factors. Of course, it's the right of victim, it's the right of personal liberty also that an accused has. But apart from that, you have to consider the impact of the crime on the society. You have to consider whether the victim will be impacted if the convicts are released. Now, today, if you think about Bilkis Bano, I mean, I think she's residing in the same village where she was. Imagine the impact on her psyche if tomorrow or for the past 6 months these convicts have been walking around in the village. I mean, what faith does one have in the justice system? In Lakshman Naskar, Supreme Court also said you have to consider whether the convicts have the potentiality of committing the crime again. So over here, the 11 convicts, when they were out on parole, one of the charges against one of the accused convict was that he actually molested somebody. So the potentiality is there, the threat is there, the impact on the society is there. This is a case which will, if the convicts are out, it will shake the belief of several women in the justice system. And here we are looking at the gang rape of a woman who was 19 years old, 5 months pregnant, her 3-year-old daughter was killed. I mean, what can get more heinous than this? So it will be a very absurd situation if, in a situation like this, convicts are outside on parole.
Right.
So yeah, of course, liberty has to come with constraints, and I think over here the constraints should be considered by the appropriate government, which is Maharashtra
And
now.
quite clearly, Anuja, the Supreme Court is, holding up the rule of law as its,
Yes.
fulcrum of augmentation and argumentation. It's saying it is through power of judicial review conferred on independent institutions like the High Courts and the Supreme Court that the rule of law is preserved. It says this court must be a beacon in upholding the rule of law. But Ashok, Anuja did talk about a pertinent aspect over here about Bilkis Bano. She's back at home. The respondents are already out. They've been out for the longest time now. The effect on her psyche as well. Usually in a big court case, the news headlines would say relief or reprieve for somebody and a big win or loss for somebody. Is it safe to say here that it is in fact a victory for Bilkis Bano? At least the quashing of the remission?
Oh, well, I would definitely see it as a kind of a victory for Bilkis Bano. Now, this is not, this case is something which she's been fighting for almost like 2 decades. First, she wanted to register an FIR which was not registered, but subsequently when an FIR was registered by the Gujarat police, names of certain people were dropped. Then subsequently she comes to the Supreme Court for transfer of investigation from Gujarat police to CBI, then transfer of case from Gujarat to Mumbai, and then the whole process that took place in Mumbai and the Mumbai High Court, the Bombay High Court, and subsequently again 18-20 years later the matter has come to the Supreme Court. Now, as we were talking about this whole business of the rights of the personal liberty of the convicts and the rights of the rule of law and the rights of the victims. Now, it looks that as Justice Nagarathna is reading out the judgment, it looks that she's building the case in favor of the rule of law, saying that rule of law must be preserved, unmindful of the ripples and the consequences it may have. So probably going by the drift of her sentence or the order she is reading, it looks to me that she is going to send the convicts back to prison.
Well, all right. Time for us to slip into a quick commercial break here. But ladies and gentlemen, let us quickly, sort of give you a summary of what has happened so far. Justice Nagarathna and Justice Ujjal are still reading out that particular judgment. And the main points that have come out is that Gujarat government was not competent enough. The remission order was bad in law. The respondents, they suppressed some facts from the Supreme Court, and now there is the path-breaking aspect that you spoke about, that it is only where the trial happened and that state government that is actually competent enough and can be approached. We're going to slip into a quick commercial break here. Lots more coming right on the other side on the Bilkis Bano case. Don't go anywhere.
वर्ष 2070 तक भारत नेट जीरो का लक्ष्य हासिल करेगा.
There is certainly a wall of capital coming into the clean tech, climate tech space, not just in India but across the world.
This and more, streaming on world's first news OTT, News9 Plus. Download now.
The scale of the attack was something that we were surprised at. David Hadley was a double agent. The Americans did not want him to be fully exposed, so all that he probably shared with the Americans was not shared with us in terms of intelligence. If we had that, I'm sure that we would have been able to deal with the situation far better.
This and more, streaming on world's first news OTT, News9 Plus. Download now.
Yes, the scale of the attack surprised us.
when you get a series of alerts, 16 intelligence alerts, if Maharashtra government at that time had alerted the Coast Guard and the Navy, this 2611 would not have happened at all.
And one of the details they had planned was to use these dhagas to mislead the investigative agencies.
All this was to be presented as a Hindu terror.
So it was a Pakistan operation. The LET was the front end.
As the attacks were on, it was clear that they were planned and launched from Pakistani territory.
For all of those victims of terror that was exported from Pakistan over the years, including but not limited to 2611.
This and more, streaming on world's first news OTT, News9 Plus. Download now.
Hello and a very warm welcome. Thanks for tuning into News9 Live. We're continuing with our broadcast on the Bilkis Bano case. The Supreme Court has given its judgment on the remission order on those 11 convicts that were released back in the 15th of August in 2022. Now, it seems like the big breaking news that is in fact coming out of this is that all the 11 convicts will now have to surrender and go back to jail within a 2-week period. Within this 2-week span, they have to surrender. The bench, of course comprising of Justice Nagarathna, who was reading out the judgment, said that the remission order was bad in law. Gujarat government was not the competent authority in this particular case. And the respondents back in 2022 played a fraud on the Supreme Court. They suppressed the information and this path-breaking find that we're now learning. Of course, there is a bigger debate in terms of rule of law over personal liberty, which will take shape, I'm sure, in various news channels, and various researchers will also put their opinion out on it. But these are the main points that we're learning now. Surrendering in front of the jail, back to the jail within a 2-week period. Of course, a big victory for Bilkis Bano.
Yes, now what Justice Nagarathna has said in our order is that it will be in fitness of things that these people have not served out their full life sentence. They were given premature release, and now that considering that the Supreme Court has set aside the Gujarat government's remission order as illegal, what logically follows is that these convicts who were released in August 2022 will have to surrender before the jail authorities within a 2 weeks' time. And once they are in jail, they can then apply for remission with the Maharashtra government. Now, why Maharashtra government? Now, this is where this is the most contentious or controversial part of the debate that was played out in the Bilkis Bano case in the Supreme Court. On one hand, the convicts said that the incident occurred in Gujarat, they were jailed in Gujarat, and hence they were entitled to a remission under the Gujarat government's remission policy. And the Supreme Court in 2022 also said that, fair enough, going by your arguments, the place of incident is Gujarat, you are jailed in Gujarat, you can apply for remission before the Gujarat government. The Gujarat government subsequently releases them on 15th August 2022. So today it's almost like 18-19 months that the convicts have been out of jail. They have enjoyed the benefits of remission, but almost 18-19 months later, the Supreme Court is putting the hands of the clock back. The Supreme Court is saying that the March 2022 order of the judgment of the Supreme Court was bad in law because the convicts, when they approached the Supreme Court, they suppressed facts from the court and got an order in their favor. Today, the Supreme Court is saying 4-5 things. Number one, that the convicts have to surrender before the jail authorities within a period of 2 weeks. The remission order passed by the Gujarat government is illegal or bad in law. Number 3, if the convicts want the benefit of premature release, they have to apply to the Maharashtra government. Now, why the Maharashtra government is what is being discussed by the Supreme Court in the 4th point, and they are interpreting the law here, and they are saying that the place of occurrence of crime or the jail where they are housed, the state in which they are housed in the jail is irrelevant. But what is of relevance is where did the trial take place. In this particular case, the trial took place in Mumbai. Which is the government in Mumbai? It's the Maharashtra government. So the appropriate government, as has been given in the Criminal Procedure Code, here will mean Maharashtra government and not the Gujarat government, because the trial took place in Mumbai. So the court is saying that if the convicts, after they have surrendered, if they want to enjoy the fruits of premature release, they will have to apply afresh to the Maharashtra government seeking remission.
You know what? In that particular debate, in terms of how Justice Nagarathna was also building up a case where she was going to make sure that the rule of law was the fulcrum of her judgment, says the Supreme Court has held that deprivation of liberty to the respondents, convicts in this case, is justified. They have lost their right to liberty once they were convicted and imprisoned. Also, if they want to seek remission again, it is important that they have to be in jail first for that.
Yeah. So that is exactly the point here, was that Justice Nagarathna, when she began reading her argument, she began reading her arguments by citing Plato and the philosophy behind remission. Then she again goes on to cite from a judgment of Justice Krishna Iyer, where it talks about the compassion which has to be shown by the courts. And then she applies that philosophy of Plato and the theory of
reformative
theory of Justice Krishna Iyer to this particular case, and says that the facts of these cases are being adjudicated in the light of this philosophy and this earlier judgment of the Supreme Court. The court believes that there were 2 important things which had to be done in the case before them. Number 1 was to interpret the law around what is the appropriate government which can pass remission orders. And the second was whether these convicts, 11 convicts, were rightfully released, prematurely released by the Gujarat government. Now, on both these counts, the Supreme Court says that number 1, in this particular case of Bilkis Bano, the appropriate government which will decide on the remission or premature release of these convicts is the Maharashtra government, number 1. Number 2, the Gujarat government exercising remission power in 2022 is illegal. It amounts to usurpation of powers. These are very strong words which are being used by the Supreme Court of India. In fact, in the last few years, these are possibly the strongest words which have been used by the Supreme Court of India against a state government. The third thing they are saying is that these convicts, now that the premature release of these convicts is declared to be illegal, there are consequences that have to be followed. The logical consequence is that they have to be taken back into jail. But at the same time, there was an argument which was made by the lawyers from the convict side that, look, here is a case where personal liberty of individuals is at stake. Article 21, the right to life. If the court holds against us also, please don't put us behind bars till the new remission policy is decided. But the Supreme Court is rejecting all of that, saying that the rule of law must prevail. The orders of remission were illegal. They are set aside. As a logical consequence of setting aside of that order, these convicts who were released in 2022 have to be taken back in jail. 2 weeks' time have been given to them to surrender before jail authorities. And once they have surrendered, that is the time that they can decide to file fresh remission applications before the Maharashtra government, and it will be for the Maharashtra government to decide on the merits of their application.
Justice Nagarathna, Ujjal, Bhuyan, the justices that read out this particular judgment, you rightly pointed out that there was a lot of Greek philosophy that was incorporated right at the start, talking about reformative theory, but then, slowly and steadily, the four facets that they were, they wanted to talk about right at the beginning was whether the petition filed by the victim under Article 32 was maintainable, whether PILs assailing the remission order, were they maintainable, whether the Gujarat government was competent to pass the remission orders. They've said that no, the Gujarat government was not. It was actually the Maharashtra government, because it only matters whether trial took place, not where you're housed in jail or where the heinous crime or the crime took place. And whether the remission orders was in accordance with the law, which it wasn't. It was bad in law, and there was a fraud that was played by the respondents as well. Well, it seems like it is the end of the road, at least for the time being, for these 11 convicts. They have 2 weeks' time, as per the Supreme Court, that has ordered all the convicts to report back to the jail within a period of 2 weeks. Justice Nagarathna also went on to say that for you to apply for another remission, boss, first be in jail. You have to be in jail.
That is the precondition.
You have to be in jail to apply for another remission. Meanwhile, what I'm also being told by the control room is that we've got some reactions that are now coming. Now they've started to trickle in. Let's play them out really quickly.
Importantly, the comments of the Supreme Court also point to the culpability of the central government and the Gujarat government, led by the Bharatiya Janata Party in both cases, because it was the Gujarat government which, according to the Supreme Court, has accepted documents which the court has considered a fraud. The court has said the petitioner has come not with clean hands, and yet this is the petitioner which had the full support of the Gujarat government. It had the full support of the central government. In fact, it was the Home Ministry which encouraged and which okayed the petition made and the reference made by the Gujarat government for the release of convicts who had committed arguably one of the worst crimes in the last 2 decades. So it is a welcome order, and we hope that the hearings which are going to continue will ultimately end in justice for Bilkis Bano and for all women of this country who fight to ensure that such criminals are punished.
Well, Justice Nagarathna also went on to say that courts have to be mindful not just to the spelling of justice, but also to the contents of it. And justice cannot be done without adherence to the rule of law. Justice encompasses not just the rights of the convicts, but also the victim here. And that has been upheld. But let's also talk about the convicts. They have been out since 15th August 2022. What next for these convicts? I mean, they are going to be behind the prison bars. If not the prison bars, at least the premises of the prison within 2 weeks. But what next for them?
Well, as far as the convicts are concerned, there's no doubt that they have served a substantial number of years behind bar. They were sentenced to life imprisonment. But under various remission policies, a convict who's served 11 or 12 years, 13 or 14 years is entitled for a premature release based on his or her conduct in jail. And various factors are taken into account, circumstances are taken into account by governments while passing the remission orders. Number one is the conduct of the convict within the jail. What will be the impact of the release of the convict once they are released from the prison? Whether there has been a certain degree of reformation on the parts of the convicts themselves, because at the end of the day, they have to be mainstreamed into the society. They cannot be isolated. So here, for almost 18 months, these convicts have been out of jail by an order of the Gujarat government. Now, the Supreme Court is saying you go back behind bars because that order of the Gujarat government was bad in law. Now, where does that leave the convicts? The convicts are stuck. The convicts will now have to go behind the bars. The legal recourse they have technically is to file a review petition against this particular order of Justice Nagarathna and Justice Bhuyan. And that review petition will again come up before the same set of judges. They will try to make out a case that a relook is required, but in 99% of such review petition cases, they are rejected. Another possibility which is there is that of a curative petition. A curative petition is a mechanism by which a petitioner approaches the Supreme Court saying that there were certain facts of the case which were not disclosed to the Supreme Court while deciding the issues, and now these facts have come to light. It must be considered by the Supreme Court, and the Supreme Court hears that. But besides these two legal remedies, the only remedy that lies for the convicts is to file a fresh remission application before the Maharashtra government. The Maharashtra government will decide that remission application in accordance with the policy that was in place at the time of sentencing or at the time of the commission of offence. Here, the time of the sentencing was 2008. That was the first time when the special court in Mumbai sentenced all the accused, found them, all of them guilty, and sentenced them to life imprisonment. Subsequently, the matter went to the Bombay High Court. The Bombay High Court also upheld that conviction. The Supreme Court also upholds that conviction. So the only route or remedy as far as the convicts is concerned is to file a fresh remission application.
A fresh remission application, and for that they have to be behind bars. You pointed out earlier in the discussion that these are some of the strongest words that have come from the Supreme Court against a particular state government in the recent past, particularly. And it's really nice because Justice Nagarathna starts with Plato. She talks about curative theory, likens punishment to medicine. If a criminal is curable, he should be set free. But this seems to be like a case of the Supreme Court coming down heavily on the respondent, saying you can't fool the Supreme Court and act on your good behavior part of asking for a remission when actually that's not the truth.
Yeah. In fact, here, what seems to have gone against the convicts was the fact that they suppressed facts from the Supreme Court of India in 2022 when one of the convicts, Ramesh Bhai Shah, approached the Supreme Court by filing a petition saying that, look, I have completed so many years behind bars in this particular rape and murder case, and I am entitled to be prematurely released because there is a policy, there is a government policy in place, and I should be allowed to take benefit of that policy. And the Supreme Court in March 2022 did say that yes, you are entitled, you can apply, but which government will, before which government will that remission application lie? Will it be the Gujarat government or will it be the Maharashtra government? And at that point in time, the Supreme Court said that it will be the Gujarat government. But today, the Supreme Court has come to a reverse conclusion where they are saying that the Gujarat government is not the right authority before which a remission application will lie, but it is the Maharashtra government.
If I was a respondent, I would, quickly be, I would be quick to say that, it was you that directed us to the Gujarat government. You should have told us back then that, go to the Maharashtra government.
Well, that is the argument that can be taken by the convict, but provided that argument is available to the convict, if he or she comes with clean hands, discloses all the facts to the Supreme Court of India, that look, we had filed an application before the Maharashtra government also, and there was a negative opinion that was expressed there.
I think that negative opinion is going to come into play, and of course, the fact that they played fraud, they suppressed this fact is not going to go down well with the apex court. On that note, Ashok Wagria, many thanks for joining with us and helping us out with your insights into this big legal story that we're covering today. All the 11 convicts, their remission order, it has been quashed. 2 weeks' time is all that they have before they report back to the relevant prison authorities. And of course, from there, behind bars, they can apply for another remission. On that note, we're going to have to shift our focus here and move on, ladies and gentlemen. The Maldives government, well, wait a minute. I'm being told there are some more reactions on this Bilkis Bano story. How about we play them out for you as well?
They have very categorically stated what is the legal analysis and reason for setting aside, quashing the remission orders and directing the convicts to return to prison within a fortnight. The court has said, and it's a scathing indictment of the state of Gujarat. The court has said that the law is clear. The appropriate government is the government where the accused are tried and sentenced, which, as we know, in the case of Bilkis Bano, which is a case emerging from the violence that took place in 2002 in Gujarat. And in this particular trial, there were about 14 counts of murder, including little babies and infants, and gang rapes of women, including a pregnant woman. And in this case, the trial was transferred by the Honorable Supreme Court to a special court in Maharashtra, where they were convicted, and that conviction has been upheld by all superior courts. Therefore, the appropriate government, as has been decided by this court and which is plain in the meaning of the Code of Criminal Procedure, Section 432, was the state of Maharashtra. The court said that the order that was obtained in 2022 May from this court saying that the state of Gujarat will decide is an order which was obtained by playing fraud upon this court. All facts were not placed before the court. If such an order is obtained, that order has no meaning in the eyes of law. It is a nullity in the eyes of law. And there are many judgments of the court which have been cited. Therefore, the court has said that given all this, the manner in which the remission orders were passed by the state of Gujarat, which had no power to do so, and the state of Gujarat should have actually gone in review and said, this order is wrong, it's contrary to the law, it's contrary to the judgments of the court. But they acted in a manner by granting, and they said a few things about, I'm yet to read the judgment, it has yet to be made available. They also said that the arbitrariness with which the discretion was exercised and the usurpation of power by the state of Gujarat, for all these and more reasons, rule of law must prevail. The court will uphold the rule of law, and therefore all the convicts have been directed to go back to prison within a fortnight.
Well, just like the advocate stated there, the finer print is yet to be made available. But there were certain questions right at the beginning of this hearing that the focus was on to answer. Whether the petitions filed by the victim under Article 32 is maintainable, whether PILs assailing the remission order, are they maintainable, whether the Gujarat government was competent to pass this remission order for these 11 convicts, and whether the remission orders were in accordance with the law. Now, after the judgment, it seems the biggest news is that all the 11 convicts will now have to go back to jail because that remission order has been quashed by the apex court. They have upheld that the Gujarat government was, quote unquote, not competent to carry out this remission order. It had to be the Maharashtra government where the trial actually took place after it was shifted from the Supreme Court to the Maharashtra High Court, to the Bombay High Court. And of course, the Supreme Court, beginning with the fact that reformation is the way to go, that the heart of the reformative theory is that if a criminal does, end up showcasing good behavior, does end up with better behavior inside the jail or inside the prison, they must be let out. Curative theory, it likens punishment to medicine, citing Plato as well. But from then on, Justice Nagarathna and Justice Bhuyan, they've said that they played a fraud on the Supreme Court. They did not tell the Supreme Court that they had already moved an application with the Maharashtra government, and the Maharashtra government came back with a negative answer for the respondents in this case before they had finally asked the Supreme Court to let them move the Gujarat High Court, and using the 1992 remission policy is how they finally ended up being released on the 15th of August on Independence Day on the in the year 2022. So they have to surrender now. The order was bad in law. Gujarat government was not competent. Gujarat government was absolutely not competent, and they suppressed facts from the Supreme Court, played a fraud on it. Of course, there is a bigger question about, right to liberty, and is that above rule of law or not? Well, according to the Supreme Court in this hearing, it's not. For another remission order, go behind bars, ask for another remission order. Lots more coming right on the other side. We have to slip into a quick commercial break here. Keep watching News9 Live.
It was my 14th birthday.
On birthday, daughter waits.
Home missing father.
He was carrying a cake for his daughter.
49-year-old Birmingham-based
Indian diplomat vanishes.